case is a poster child on why family law attorneys must litigate with clean hands. Here, the parties settle their divorce. Dad pays some alimony and child support. He later gifts his cell phone to, one of his children for reasons unknown. He leaves all his private messages on that cell phone. Mom later accidentally finds an email between the lawyer and her ex suggesting he lied about his income during the divorce. She runs out, files a 1401 petition to vacate. Dad files a motion to strike saying, well, that email is protected by attorney-client privilege. Now, 615 motions to strike are legal arguments, not evidentiary, and this is going to be important in just a second. The judge grants the motion to strike, Mom appeals, and the appellate court reverses. Attorney-client privilege isn't absolute, and there are a few exceptions. One of them is what's called the crime-fraud exception, and it means, well, pretty much what it sounds like. If the client's communication is designed to commit a crime or further a fraud upon the court, it isn't privileged. And it works one of two ways. One, you're conspiring with the lawyer, in which case the lawyer might as well hand over their ARDC card to the judge. Or two, the client is attempting to deceive the attorney. Now, in the former case, the privilege won't apply, period, because, well, it's illegal. In the latter, it still doesn't apply because the attorney's advice had been obtained by fraud. Now, context is crucial. If a client says, hey, David, what happens if I were to go up to the judge and say X to him, and if I were to tell him in response, the judge might do this?
Nope, stop talking, go to jail.
That's not crime fraud. That's me telling the client the consequences of saying that to the judge. Likewise, if a client says, hey, sometime back I did this thing, and I tell him the best ethical way to defend against that charge, that too doesn't trigger the crime fraud exception. That's because crime fraud requires that the client knows the advice they're seeking is to further a present crime or fraud upon the court. And it must be pretty clear on the face when holding an evidentiary hearing that the communication has some intent to further that crime or fraud along. Here the appellate court says, hey judge, you still might be right here. You just need to have an evidentiary hearing on it. So it gets sent back for that, and I guess we're going to see what happens. Now, the opinion wisely abstains from posting an excerpt of the email since it hasn't been established whether it's protected or not. But the gist of the opinion suggests that it was possible the lawyer was at least on notice that something wasn't cooking right. Now, we're supposed to take an oath, but let's pretend that that's not even a requirement to be a lawyer. There's really two very good reasons why lawyers should never get involved with clients who want to do shady stuff. The first, those clients have zero hesitation throwing you under the bus once that lie is discovered, especially if there's emails or documents that suggest you knew, or worse, turned a blind eye. Because although court is like this, it's also very much like this as well. Which leads me to number two, once word gets out that you're on the take, nothing that comes out of your mouth will be trusted by the judge or opposing counsel ever again. Your reputation is trash, and you'll be out of business, and rightfully so, very quickly. Anyways, that's all I have. Thanks for watching.